Good afternoon, everyone. I am Carla Zevnik-Seifzer, both an advisor and president of ClearStep Financial. And today we want to welcome you to today's estate planning presentation. Please be aware it will be recorded, and please make sure you have your microphones muted and cameras turned off during the presentation. We appreciate it. And then our goal at ClearStep is to help educate and guide our clients through the ever-changing financial world. How many of you see that our world is changing right in front of us? I know everyone's raising their hand. To help us accomplish this goal today, I am pleased to introduce to you our guest speaker, Rachel Dahl, attorney and partner with DeWitt Law Firm. And I believe you will find Rachel's presentation both educational, informative, and enlightening. And with that, I want to welcome to the presentation as I turn it over to Rachel. Go ahead, Rachel. Thank you. And then we'll take questions and answers at the very end.
Thank you so much, Carla. I appreciate that introduction and the opportunity to be here and to present to your team and your clients this afternoon. As Carla mentioned, my name is Rachel Dahl. I'm an attorney licensed in Minnesota, Iowa, and South Dakota. I've been doing this for going on 20 years. And this estate planning topic is one that it's always timely. The best time to address your estate planning needs is always today, rather than putting it off until tomorrow. And this hour we spend together here today, we're going to go through some basics, answer some questions, clear up some urban legends, and give you all a better understanding of what this process looks like and why you do it and what goes into it. So I'm going to share my screen here. Yeah.
While you share your screen, if I can interrupt for a minute, that this information on estate planning, I know you're licensed in a few states, but this information is valuable to people in all states.
That's correct. That's a very good point.
So I just want to, and at the end, Rachel can answer questions, but estate planning in general, the laws are over all different states. They're the same types of valuable information. So thanks, Rachel.
Right. By the way, Carla, I'm looking for the share my screen option here. And I'm wondering if something has to be triggered on your end to allow me to do that.
Nathan?
Rachel, you should have permission. Bottom of your screen should be eligible to share.
Yeah, I'm not seeing it. It's not coming up. Let's see. Maybe, Nathan, can you maybe call it up and maybe I can just direct on your end, just kind of have you advance as we go?
Yes, I think I can do that. Did you send your slide deck to Dave?
I did. Yeah.
Perfect. I will get that up very shortly.
Okay. So that sounds great. In the meantime, for our listeners, I'm going to go ahead and I'm going to walk through, what this looks like when you're getting started and, what commonly drives people to come in to begin this process. And usually the types of questions people are thinking about or the concerns they have are, if you're a young family, for example, and you have minor children, usually it's going to be who takes care of those kids if something would happen to the parents, and that would mean guardianship. And so that's a really common entry point where young families are looking to get started with the planning process because they're looking to protect the kids. And what happens, right, to the kids in terms of taking care of them financially. So parents are looking to put together a plan that establishes guardianship, conservatorship for the kids. In addition, let's say that someone has children that are older, they're adults, maybe they're not as financially responsible as what mom and dad might hope. And in that case, we're talking about how to structure a plan that helps preserve an inheritance for a longer amount of time. The average inheritance is gone in about 3.5 years. And oftentimes families don't want to see that happen. There's also going to be concerns about who receives when someone passes. And maybe the state laws in the state you live in, it would mean that someone's receiving from you that you don't want to receive from you. And so careful consideration needs to be put into the process to determine who should be a beneficiary and what should they receive. We also want to consider blended family situations, and stepchildren don't inherit the same way that an adopted child or a biological child would inherit. We also have quite commonly people who have concerns about children or family members who may be disabled. And if that's the case, those individuals, they don't inherit the same way that someone who is not disabled would inherit, because they oftentimes are receiving public benefits, and receiving an inheritance can be problematic in terms of them continuing on with their public benefits. We also have people who really want to have a better understanding and a process put in place for times of disability for themselves. So what would happen to you if you were incompetent, you were in a coma, you couldn't speak for yourself? And medically, financially, you would want somebody who could step in and speak for you, make decisions for you while you're still living, but you can't quite do those things for yourself any longer. We also have tax considerations, and frankly, these days, probate has become a word or a process that people want to avoid. We'll talk a little bit about that further on in the presentation, but these types of considerations and questions people really want to know more about, and it's usually what drives them in to start the process in the first place. So realistically, what you want to do in an estate planning situation, you want to give it your time, your attention, and your resources, so that with careful planning, you give more of your estate to the individuals that you want to. And it's a process. So once your documents are done, it doesn't mean that 10 years or 15 years down the road, that plan might still be the best plan for you or your family. So this is something that we want people to understand is really going to be a long-term investment to make sure that your plan always works for you and your family. And so benefits of putting some things in order: we can plan for times of disability, we can plan to avoid probate, we can plan to reduce or eliminate transfer taxes. And what I mean by that are estate taxes. Okay, so the federal government has estate taxes. Right now, it's a really large number that each of us has to leave anybody we want to tax-free. In 2026, the magic number is $15 million. Most Americans don't have to worry about federal estate tax. In Minnesota, we have estate tax as well. Wisconsin doesn't, Iowa doesn't, South Dakota doesn't, and North Dakota doesn't either. But Minnesota is an island here, and we do have a $3 million estate tax exemption amount. And so we want to be mindful, first of all, where you live and what the rules are in your home jurisdiction. But part of this planning process, we factor in where you live and what you have in terms of assets, and whether or not tax planning needs to be something that we're talking about. We also want to make sure, and you have the benefit of providing for your loved ones. You say who gets what, when they get it, how they get it, and who's in charge. And with that is really peace of mind that comes along with the process. There we go. Here we go. Nathan, if you would please go to slide 9. I think we're at about slide 9. There we go. Wonderful. So in terms of the planning process, it's a fairly linear process. And the first thing I'm going to ask someone who I'm doing planning for is, what are their objectives? What are their needs? What are their goals? We want to be very clear about what we're to do. Oftentimes people have an idea of something, a trust, for example, a type of will that they want to use. They saw it on the internet and they think that it's the right thing for them. And part of the process is really drilling down and understanding what's driving that. Okay, because there are a lot of different types of mechanisms out there and tools we have at our disposal. We want to make sure that everyone is getting what they need and their goals and objectives are met. So to do that, there's a lot of fact gathering. We gather facts about the family. Is this a blended family? If it is, do we have a prenup involved? If it is somebody who has a taxable estate, what are the assets? If we have someone who has real estate in multiple jurisdictions, we know that there might be a better plan for them than something else. And so all of these things are analyzed: assets, family information, debts, type of assets, and the value of the asset, so we can do tax planning. Once that's analyzed, then we develop a plan and the plan gets implemented. And periodic review is necessary because oftentimes people will outgrow their plan, and that's normal. If you are just starting out and you have a young married couple with their first child, that type of plan that I would recommend for them is very different, very likely than what I would recommend for a couple who is nearing retirement age. They don't have minor children, and they're looking for more tax planning than guardianship or conservatorship for children. So things do change. Let's go to slide 10, please. Okay, so we're going to dig a little further into some examples of wills and trusts. We're going to spend some time talking about powers of attorney, healthcare directives, and other types of documents that make up a typical estate plan. And let's go to 11. What we're going to talk about a little further is ways that we can pass assets to heirs, to beneficiaries, to anybody that you might want to. And there are basically three different major types of documents or ways we can pass assets to others. We have beneficiary style assets, we have wills, and we have trusts. And beneficiary style assets, those would be things that are considered non-probate assets. So you don't need a will, you don't need probate, you don't even need a trust, okay, to pass these assets to a beneficiary. So when we talk about beneficiary style assets, all right, let's move on to the next slide. You can leave beneficiary style assets to an individual. So you can decide, for example, an IRA or a life insurance policy. Those would be types of assets you could designate a beneficiary for. You can name your spouse, your children. You could name your trust as a beneficiary. If you wanted to leave money to a charity, and by the way, retirement accounts are wonderful assets to leave to charitable institutions because the charities don't pay tax on those assets, and we often look to those types of assets for charitable contributions. If you wanted, you could leave a bank account to an entity such as an LLC or a corporate entity if that was something you wanted to do. And sometimes that works in situations where we have a family cabin LLC and you're looking to provide some liquid resources to the next generation. That's a great way to do it on a beneficiary form. So let's talk about, dig a little deeper and go into the next slide. So types of assets that you can leave to a beneficiary, all right? You usually are provided with a document, either at your place of employment, or it's where you have your assets invested, or it's where you have a checking or savings account. And any of the types of accounts or assets that are listed here are quite common in terms of setting them up with a beneficiary designation. We call these POD or TOD assets, pay on death or transfer on death. And here's the nice thing about this, they're often viewed as being very simple. an individual, you can put the individual's name on a beneficiary designation, allocate percentage that this person should receive. And once you pass, the individual brings in a certificate and their identification, and there's some simple paperwork that is done to transfer title to the asset into the beneficiary's name. It's clean, it's simple, it's easy. The problem with these types of assets and leaving it on a beneficiary designation is that what you get in convenience, you give up in control. And oftentimes, clients are looking to structure their estate in a way that provides more direction. And they're looking to protect assets for the next generation. They don't necessarily want assets to go directly to a beneficiary for any number of reasons. Maybe the beneficiary isn't savvy in terms of finances. Maybe they've struggled with addiction issues, and giving the asset to a beneficiary outright isn't what someone wants to do. And so if that's the case, then we would structure and we would encourage you to leave your assets with either a will or a trust in place that governs how the assets are to be distributed to the beneficiaries and what the rules are. So now let's talk about what a will is and what it does and what it doesn't do, because there are a lot of urban legends out there. And I think the biggest one is that if you have a will, your estate gets out of probate. And this is not true. A will is a ticket to probate, okay? You in a will say who gets what, when they get it, how they get it, who's in charge. In order to use the will, it has to be probated. It has to be sent into the court. And the court is just a process of administering someone's estate, but it is a probate situation. And that might be just fine. In a typical will, what you're going to see is the person who makes the will, we call that person the testator. The person who's responsible when the testator dies for carrying out the testator's wishes and taking an inventory and making sure that their last bills have been paid and everything has been properly administered, that person we call a personal representative. And it's synonymous with the term executor. The individuals who receive the assets in the will, we call them devisees or beneficiaries. And we have a couple ways in a will or a trust that gifts can be left to the beneficiaries. We have specific gifts, and that would be the type of gift where the testator would say, I'm giving $5,000 to John Doe. And it's called out very specifically. Names are used and amounts or percentages or a specific asset is generally given to that specific beneficiary. Then we have what's called the residue. And you can think of that as just synonymous with the rest. So after our specific gifts have been made, then typically the rest of the assets would go into the residue. And the residue very commonly is split out in shares. They could be equal shares. They could be unequal shares to the other beneficiaries. And we have what we call administrative terms. Those are the rules, and those are the instructions for the personal representative to follow. Now, if this is a situation where we do have minor children, there would be guardianship provisions in the will. And one thing that is also an urban legend is that someone can step in and you can name a guardian for minor children in a trust. This is not the case because the court has a vested interest in making sure that minor children are properly looked after and their needs are being met and their rights are being protected. So the proper place to find guardianship provisions would be a will. The will is sent to court, and The guardian nominated by the testator is oftentimes the guardian who is actually appointed and confirmed by the court. Not always, because the court will do a background check and make sure that this person who's nominated is fit to serve. So now let's move on to the next slide. And when we talk about a trust, very, very similar. You say who gets what, when they get it, how they get it, who's in charge. We have some different terms though. Instead of being a testator, we call the person who makes the trust the grantor, the trustor, or the settlor. Those three terms are really synonymous and interchangeable. The person who's in charge of administering the trust and taking care of business, we call a trustee. Similarly, we have beneficiaries of the trust. And then the next element of a trust that is necessary is property, okay? And we think about a trust as though it's a bucket. We're putting assets. We're putting the grantor's assets into the trust, and we're retitling those assets most of the time when the grantor is still living. And so the trust would contain trust property. It actually has the title to the property. And then very similar to a will, we're going to have administrative terms. We define rules, responsibilities, and the obligations of the trustee. And so now let's move on to the next slide, please. So now we've gone over some of these terms before: personal representative, trustee, guardian. We also use the term attorney in fact and healthcare agent quite a bit when we're talking about estate planning. These are different terms, but all of these terms really define roles that people are going to play in your estate plan in one form or another. And they're very different in terms of what they can do and can't do, and to what property they have control over. But ultimately, all of these roles, they are fiduciary roles. And fiduciaries are individuals who are essentially acting for on behalf of others. And they have certain legal obligations and duties that they owe. So personal representatives, trustees, they have legal obligations they owe to the beneficiaries of a trust. They have to ensure that what they're doing, or the will, they have to ensure that what they're doing is in the best interest of the beneficiaries. Any guardian or conservator for a minor or an adult, they have to look out, okay, for the ward. We call that person a ward or protected person. And so the people who are fiduciaries are constantly looking out for the best interests of those wards. An attorney in fact, who's operating under a power of attorney, or a healthcare agent who has been appointed under a healthcare directive. They are acting in your best interest. If you are the person that created that power of attorney or that healthcare directive, these fiduciaries owe you an obligation to look out for your best interests and use your assets and financial resources for your benefit as attorney in fact for you. And they have to look out for your best interest medically and abide by your wishes medically under the healthcare directive. All right, let's advance. So let's talk for a moment here about a typical will structure and what this looks like. I like visuals, so this slide I think represents visually the flow of what this type of will would look like. We call this a contingent trust will. And for our listeners, there are a lot of different types of wills out there and a lot of different types of trusts, okay? So this particular type of will is designed, this would be, a great will for, let's just say you're giving everything to your surviving spouse, okay? Great, maybe not for a blended family situation, maybe not great for people who are in a taxable position with estate tax, but a very basic, simple will. So the will, remember, is a probate situation. This is a probate estate. As we proceed down the slide, specific gifts come out first. And then debts, expenses, and taxes are paid. The personal representative takes care of that. Typically in a marriage, the residential real estate, whether it's a homestead, maybe it's a homestead and a cabin, you can decide, but typically it's the homestead would go to the spouse. And then this is designed to either flow to a certain spouse receives everything, or if the surviving spouse does not survive, then we have whatever is left going to the family trust. And so this would be a really good type of plan, basic will for particularly a younger family, where if everything is going to the surviving spouse, the presumption is he or she is going to take care of the minor children and carry on. But if both parents have passed, then we have these resources going into a family trust, which would provide terms, rules, and structure as to what would happen with the funds when we have minor children, or it could be just other family members, but who should receive and when should they receive? Typically, if this is a family with minor children, then we would have a trust continue for the duration until these children are adults or they've reached certain age milestones. And all of that is completely customizable. So there isn't a one size fits all. What works for some families doesn't work for all families. So let's proceed now and go into some tax terms here. So I've mentioned estate tax and being tax efficient a couple times. And so here are the magic numbers. I had mentioned them earlier. And I'm also going to now introduce this number of $19,000 because this is our annual gift tax exemption. So the tax terms that most of us are going to take a look at, if you're a Minnesota resident, it's $3 million per person. Again, the federal estate tax exemption amount is $15 million per person. And if you're joining us from Wisconsin, you may not have to worry about either of those numbers. But if you are in a taxable position, we want to know and help you make some plans ahead of time so you can leave more to your family, or at least decide how you want to be charitable rather than leave it to your state or federal government to decide in the form of tax owed to the state or the federal government. So $19,000 per donee. What this is it's the annual gift tax exemption. This is the amount that each of us gets to leave anybody we want to without having to disclose this to the federal government. And this is an annual amount, okay? So this year, if I wanted to give my brother $19,000, I could do that. I could write him a check and I don't have to tell anyone. Now, if I left him $20,000, I could freely do that. There wouldn't be tax associated on that at the time, but I would have to report to the federal government on a special type of tax return that I had exceeded this $19,000 to my brother. And so these numbers may or may not factor in for you, but we want people to be aware that there are rules for how much you can have when you pass and how much you can give during lifetime. So now let's talk about a different type of will. Let's go to the next slide. Thank you. This is what we would call a disclaimer trust will. And I put the slide after the tax terms because this is a very, very common type of will or even a trust. You can set it up in a similar fashion that we would see if you were somebody who, for example, was a Minnesota resident and you and your spouse had $3 million, $4 million to your name combined. Again, this is a will. So visually going down, this would be a probate estate. Our specific gifts, debts, residential real estate, all of those things get dealt with right away. And now we come down to the bottom of this slide and we have if spouse survives or if spouse doesn't survive. If spouse doesn't survive, well, that's a simple route that goes to the family trust. The rest goes to the family trust. But now let's say that there is a surviving spouse. Now the surviving spouse is going to have a decision to make in a structure like this. The surviving spouse can say, I want to take everything that the deceased spouse is leaving me, or maybe it isn't a good idea to take everything because there might be tax to pay if I take everything. What I take might push me over what I'm allowed to have, and then tax would be owed on my death. The fancy legal term for saying I don't want it, that's what a disclaimer is. That's all disclaimer means. It just means that you don't want it. But spouses really often want to take care of each other. And so letting go and saying you don't want something is sometimes not the best scenario. So what we do is if the surviving spouse says, I don't want, $500,000 that my spouse is leaving me. Well, they're free to do that. And if they say they don't want it, instead of going outright to the surviving spouse, it goes into a special trust called a disclaimer trust that the surviving spouse is able to use. Income goes to the spouse. Principal, that can go to the spouse as well. And oftentimes our surviving spouse is the trustee, so you get to manage. Okay, let's go on. So again, if the surviving spouse says that they don't want a certain amount or they disclaim certain assets, they still are taken care of. And they still can have an active role in how those funds are used and when they're distributed. Oftentimes, once both spouses have passed, if there are children involved, what's left goes to the children or in a trust for those kids. And let's advance. In a family trust, in any trust, we want to make sure that you have decision makers, right? You have somebody who's there who can manage these resources. That person is the trustee. And if you are creating the trust, you get to nominate the trustee. Oftentimes, while you're living, you are the trustee of your own revocable living trust. Could be you and your spouse. And then you decide, you nominate someone who's going to take over the role of trustee once you've passed. It's advisable you think of a couple different individuals, so if one can't serve, you have a backup. But that trustee's job is to manage the assets. They distribute the income and the principal. Sometimes the trust they're directed to make distributions at certain ages. It's common to have age-based staggered distributions. 25, when the child hits 25, maybe they get a fourth of what's in their trust. Then they get another fourth at age 30, and then maybe they get the rest at 35. What I've seen more commonly over the years is people like the idea of if a child is responsible, he or she can be trustee of his or her own trust and have some discretion to take money out or leave money in. Because whatever is left in that trust is protected from creditors and predators. And giving the child or any beneficiary the discretion to pull funds out or leave funds in a protected bucket is a nice way to handle it. So there are a lot of ways that this can be structured. And then, of course, you can have supplemental needs trust or special needs trust provisions that are drafted into your will or your trust. And this would be useful in a situation where you have a beneficiary who is receiving public benefits because they are a disabled individual. And we don't want their inheritance to be counted against them for public benefits. We don't want to kick them off of their public benefit program and have them be forced to spend on their inheritance before they qualify again. So you can do a lot of things with these types of documents that can do a lot of good for your beneficiaries. All right, so let's advance. Here we go. Duties of the trustee. They invest and manage the assets, and they have to be prudent about that. They are fiduciaries, and so they have to take good care of the resources they have under their control. They're going to be the boss when it comes to distributing income and principal. You give them the rules. You can say you have discretion to make distributions for certain reasons, or you say you have to make distributions under certain conditions. And so they also are going to take care of housekeeping, right? They're going to file tax returns. And if there are problems, because remember, this is now the trustee. This isn't a personal representative. We don't have a court involved here. This isn't a probate. The trust is a non-probate structure. So largely, we don't involve the courts at all when it comes to the trust and its administration. However, if there are problems, if a beneficiary keeps requesting resources, they want distributions again and again and again, they threaten the trustee that they're going to sue them, or they're asking the trustee for something that isn't really explained in the document, they have an unusual request, the trustee is likely to go ask the court to interpret this or give them instruction so that they can resolve the problems without getting sued. Okay, let's advance. Okay, now for minor children, if you do have minor children and a guardianship or conservatorship is needed, the district court must confirm the appointment of that guardian. Again, background checks are done, and we really want to make sure that these kids are adequately taken care of and their best interests are kept in mind. So the court confirms the appointment, and the guardian's responsible essentially for stepping into your shoes and being that parent figure. They're taking care of the day-to-day needs of the child. They are under certain obligations, not just to the children, but to the court as well. And they must report to the court annually about how this child is doing, and what, and they have to keep that every year that they are a guardian, they have to do this. It's an annual requirement. Now, let's say you have a guardian, but not a conservator, because you have a trust in place and the trustee is managing the money. The guardian and the trustee work together, okay? And sometimes it can be the same person with different hats. And that's okay, as long as that person is responsible and trustworthy. Sometimes people like to put different individuals, one as a trustee and a different person as guardian, because they see it as checks and balances. The trustee then is responsible for the financial needs of the child. The guardian would go ask the trustee for the financial resources that are needed. Okay, now let's quickly touch on what is probate. Probate, it's simply a court supervised transfer of assets when someone dies. If you pass away, you're not here anymore to transfer your assets or sign title over to the people that you want to receive the asset. So again, this can happen in an intestate situation. That means someone doesn't have a will. So really what you have is the will your state gives you. If you do have a will, probate is still required. And we would admit that will and petition the court to open up a probate proceeding. Everything is inventoried and valued, and debts are paid, last taxes are filed. The court is provided with an accounting, and the personal representative accounts to the beneficiaries or the heirs. Once this is done and everything is approved, distribution of the estate can happen. Now, let's talk about some pros, cons here about probate. So let's go to the next slide. So probate, as you can imagine, it's more expensive to do administer an estate via probate than it is through a trust. So one of the downsides for probate is the cost. And think of it this way, a will and a trust, I think they're fairly equivalent in terms of the cost, The difference is, when is that payment? When do you make the payment for it, and who's responsible for making the payment? It's cheaper to put a will together. It's more expensive on the back end to have that will administered or probated. It's costlier on the front end to set up a trust because we do more work in the front end, so you don't have as much work on the backside. And so really what we have here are some costs that go into the probate, and we also have some time commitment. Okay, because if it's a court process, we're dealing with the court rules, but state law also has to say, and the reality is a typical probate is going to take at least 6 months, because typically every state is going to have creditor periods where, if you look at your newspaper, you're going to see in the legal section, there are going to be mentions of probates, okay, or estates that are going through the court. That is done. We publish notice of a probate to give creditors the knowledge that someone has passed and they have a limited amount of time to file a claim. They believe they're owed money. And typically that time frame is about 4 months. So a probate is usually going to take 6 months or longer. And these days, one of the downsides is that this is public. It used to be that your neighbor, your nosy neighbor, could go down to the courthouse and request to see, what you had. It's all public information. Who had what, who's getting what, and that bothered people. These days, that isn't the biggest concern anymore. Now it's really about data. And there are companies that pay a lot of money to understand the transfer of dollars, assets, who's getting this money. And that, I think, is what bothers people more so these days. It's not necessarily the neighbor or someone down the street. It's that big corporate entities are wanting this information and using the information in ways that maybe we don't want them to use or know. So now let's go on. If this bothers you, if these things bother you, then what you're looking for in your planning is to have some type of non-probate transfer put in place. So joint tenancy, very, very common when we have a married couple that owns a home together. Okay, all it means, joint tenancy with right of survivorship. If I own my home with my husband, the minute I die, if he survives me, he becomes sole owner. Didn't really have to do anything. Okay, very, very common for married couples. Pay on death, transfer on death. Those are things we talked about for beneficiary designations. Those happen very, very quickly with very little paperwork. Transfer on death deeds. These are special types of deeds that you can use to transfer title to your home to someone that trigger automatically when you die. Now, with these types of deeds, they can be great tools or they can be horrible, depending on title, how many people you're putting on title, do they get along, are they going to be able to work it out? And most trusts, so we've talked about the beneficiary designation, most trusts, and I say that because trusts, again, they're like buckets. We want to put assets into the bucket to avoid the probate. If asset transfers during life don't happen, or we don't structure something going to a trust on a beneficiary designation, then that asset may have to be probated to get to the trust. We try to avoid this, but most trusts can do that. Okay, so now we've got our revocable living trusts. These are very, very popular ways to structure an estate plan. So we've got, again, some terminology here. Beneficiaries, if it's a revocable living trust and it's your trust, you are typically the beneficiary during your lifetime. Usually there are instructions that you can receive assets, put assets into your trust, take assets out of your trust, revoke it in any way or in whole. Now, after you pass, you'd have instructions about who should receive your estate, just as you would with a will. Remember, who gets what, how they get it, who's in charge, when people get it. It's all very, very similar. So now let's advance to the next slide. Here is, again, a visual. So this would be a living trust, and you could create this. The trust holds title to the assets. During your lifetime, you can change it, you can revoke it, and assets are put into the trust, okay? We use things such as deeds, beneficiary designations, we retitle brokerage accounts. What assets you want to put in the trust, we have to take the time to ensure that those are properly transferred, and it's the trust that's now the registered owner of the asset. While you're living, you have full use and control assets, and you can, again, put assets in, take assets out. Any assets that are in the trust, if something happens to you and you are not able to participate, you're in a coma, something happened, you're incapacitated, a conservatorship is not needed to govern those assets because you have already said who your successor trustee is going to be in the case of incompetency or after you've passed. And there's no probate proceeding that has to be triggered to govern the administration of assets that are held in this trust. So it's faster. There's no requirement to hold this thing open for 6 months. Your trustee can begin doing what they need to do to properly administer your trust estate right away. So this is great, especially for people who are business owners, okay? Closely held family businesses where you really need to be able to make decisions and ensure that the business assets, you don't have to wait to get court involvement or have court authority to do something. Okay, let's move on to the next slide. Again, disadvantages, right? It costs more to set this up because we have to make sure all of these assets are transferred now. So there's a little bit more work and effort that goes into this. Because we're not publishing for a creditor claim period, creditors do have a little bit longer to come back and to say that they might be owed some funds. And as much as court oversight sometimes isn't desired, the reality is sometimes you want to have court oversight because you might have beneficiaries who are behaving badly, and you might have somebody who goes rogue as trustee, meaning they're not following the rules and the beneficiaries are concerned. The good news is that in either of those situations, either the trustee or the beneficiaries have the right to seek out court oversight if they believe it's necessary. Let's advance. Okay, so now one of the things that people are concerned about is, how do I ensure that my beneficiaries are not going to be dependent? How do I encourage good behavior? And again, keep in mind, there isn't a one-size-fits-all situation. So you can customize your document to say what you want to say. And oftentimes people will do that with a mission statement. They can say what's important for them, state what their values are, and state why it is that they've given the trustee certain instructions or prepared the trust in a way that is more or less structured. Now, you can decide, and I just chose age 25, but at a certain point, you could tie income distributions to earned income, okay? So somebody has to be actively earning an income to be able to receive distributions from the trust. It means they're not just sitting back and not being productive and receiving assets instead of earning income. So that's possible to do. You can have the trustee require the beneficiaries to put together a budget and to sit down with them on an annual basis to see what they're doing with their distributions. You can also have awards tied to certain things. That could be getting an education, starting a business, whatever you might want for your family or think is appropriate. There are trusts that we call dynasty trusts that they go on forever. And so there isn't a distribution that a beneficiary gets at a certain age, and maybe they never get all of what's in their account, their trust account. That's very common, especially for high income, high net worth individuals that want to really establish a legacy. And so you get to determine what works best for you and your family. Now let's move on. Let's talk a little bit more about gifting. So again, the annual gift tax exclusion amount is $19,000 person. Marital deduction for gifts to spouse, basically that's an unlimited situation. And we do have educational gifts, so 529s. And we also know that there's an exception to this $19,000 per donee. If you're making a gift to someone, but you're making the gift directly to an educational institution, or you're making it to a medical provider, then that is an exception. You don't have to disclose on the gift tax return if you go over the 19,000. So there are ways that you can make larger gifts to individuals and not have to disclose that. Very commonly, we see people make gifts in trust. Grandchildren's trusts are very, very popular. So grandpa or grandma wants to put something in a trust and protect it for future generations. We see a lot of that happen with cash or with brokerage accounts. And the grandchildren, again, they might not receive huge lump sums, but there usually are going to be some instructions in that trust about when it's appropriate to make a distribution. Charitable giving is still done quite a bit. These days, I see a lot with donor advised funds, DAFs, and these have largely replaced the private family foundation up to that $5 million mark. So if $5 million or more is contributed, then a private family foundation might still be a great option, but donor advised funds have become incredibly popular charitable tools to make the gifts during life for some income tax savings purposes, or as part of an estate plan, a well thought out estate plan for tax reduction or just to do something good. So gifting to charity, okay, we can do outright gifts. And again, annual income tax deductions are great, especially for individuals who are now forced to take out required minimum distributions from retirement accounts. Maybe that isn't something that is helpful at a particular stage in someone's life, and they will offset that tax hit by contributing charitably. And again, either way, if you do it during life or it is something that is done upon death, it reduces the overall size of someone's estate and makes that estate tax, if estate tax applies, it makes that estate tax burden lessened. Now, in terms of split interest gifts, this would be something that you could put together as a particular special type of trust. We would call it charitable remainder trust, or CRT. And this is something that can, if you want to be charitable, and particularly if you have low basis, highly appreciated assets, you could gift the asset to it. The trust sells, if it's low basis stock, the trust would sell that stock. Because it's charitable, they don't have the same tax requirement to pay capital gains tax on that. You would get an income stream for a term of years, and once you pass or your surviving spouse passes, what's left in the trust would be given to charity. And so we do have special types of trusts. These are irrevocable and tools we can use to make charitable giving beneficial for you and the charity. So let's talk quickly now about what I call disability documents, okay? That is power of attorney and healthcare directive. And these are documents, again, you put in place during your lifetime. The power you give someone under these documents dies with you, okay? So your power of attorney or your healthcare directive is only good while you are alive. The moment you die, the power dies with you. Power of attorney, very short document, really powerful document. Okay, you put someone in control of your financial life as attorney in fact. Now, sometimes we hear what is a durable power of attorney. All that means is that the document is still effective, the power is still effective if you become incapacitated. And again, the attorney in fact is a fiduciary. They owe you legal duties, right? So they're not going to steal from you. They're not going to use your resources for themselves. And this type of document, you put it in place now. You don't have to use it now, but it's there in case you do become incapacitated. It's what we call least restrictive means. In a conservatorship proceeding, the court would ask, do we have least restrictive means? Meaning, is there someone out there, if this person is incapacitated, who has the legal authority to take care of his or her finances on his or her behalf? That's what this document allows you to do. You nominate someone to step into your shoes to make financial decisions for you if you are incapacitated, which then means if you have this, a conservatorship proceeding isn't necessary, okay? And that's a great thing because that's a court process that is time-consuming and expensive, and it's easy to put this document together to make sure that you are protected financially. If something happens to you, you can't make decisions, but you're still living. Similarly, we have the healthcare directive, okay? Here, the person in charge, you make the document, you appoint a healthcare agent. Now, this person makes decisions for you medically. They step into your shoes as if they were you. When your doctor determines that you no longer have the ability to make your own decisions, your healthcare agent takes over, okay? They can decide where you live and receive care, who your doctor is, what kind of care you want or don't want, and they have the power to request and review your medical records. And here, okay, with the financial side, we want someone who's really responsible, okay? Somebody who is going to use your money for your care. They're not going to steal from you. You trust them and they're going to show up and do what you need them to do for you. Here, you want to think about somebody who's going to make the types of decisions for you and carry out your decisions the way that you want them to. Okay, so if you're the type of person who says, I don't want to be hooked up on life support for a long extended period of time, then you think about who in your family or in your group of friends would be appropriate, who could make those decisions for you and handle that on your behalf. You don't want to put somebody in control then who's going to refuse, okay, to honor your wishes. And the same goes the opposite direction, right? If you want to say, give me a chance. I don't want somebody who, doesn't understand me or know what's important for me. I don't want them making decisions for end of life situations. You want somebody you can trust and who's going to abide by your wishes. And then these documents, you can change them. Anything we've talked about, okay, during our time together here, you can revoke them, you can revise them, you can change them in part or in full, okay? So we've covered a lot of things, a lot of topics. I'm hoping that these slides are available for you if you need them. And putting everything together, you start by thinking about what's important for you and why you're doing this. What's your why? Who is it you want to protect and take care of? Yourself and then family, friends, whatever it may be. You got to do some fact gathering and we analyze what you have in front of you, develop the plan, implement the plan. And of course, every so often, we want you to do a review because you may outgrow this plan. And I've had people say they've put together a plan in the mid 80s and they ask if it's still good. And you know what it is? The question is, should it be? Do you want it to still be good for you? Because maybe it's not doing what you need it to do anymore. Maybe you've outgrown it. Maybe things have changed. and it's time to come in and adjust it. But you get to do that. You're the boss, and you get to be the one to be in the driver's seat and make the decisions about what your objectives are and what matters most for you. So I think at this point, we may have a few minutes for some questions if there are any.
So thank you, Rachel, very much. It was excellent information, very valuable. We appreciate
You're
it.
so welcome.
Very detailed. You went into quite a bit of detail, and it's important when we're making decisions on estate planning. Those details are important in our decision-making process. So thank you so much.
So important.
Yes.
Yep.
So does anyone have any questions? If you have questions, you can go to the chat below and ask a question, or you can unmute yourself, ask a question, and then we can ask questions of Rachel. While, if anyone is thinking about a question, I do have one question, Rachel.
Yeah, go ahead.
Yes. So when someone puts down as a beneficiary, maybe it's a beneficiary from out of the country, is that
Sure.
viable? Can that be processed legally, or do we need to hire an attorney? Let's say someone passes away, they have 2 children that live in Germany.
Sure. Yeah. So the answer is it's viable. And so if it's done through a will or it's done through a trust, in a probate, we would have to give notice. We usually give notice to the consulate in that country. And we work to ensure that we have the right individual, okay, who shows up and is receiving. In terms of a beneficiary designation, okay, so let's say we're talking about a 401k, there's usually going to be paperwork involved with that. And oftentimes there are rules based on the financial institution about, when you sign up for this account, there are, of course, it's the fine print. And I would encourage you, if that's how you wish to leave something, make sure you know what's in the fine print. And what would happen. But usually, yes, the individuals who are living in another country can receive those assets, but there is an expectation that they provide the requisite information to ensure we have the proper person.
Okay, so an attorney might have to get involved, probably would need to get involved just for the money to go to a beneficiary in another country.
Maybe. But what I would say, if it's a will or trust, they're usually attorneys are involved on the probate side of things, and the court process, we have to through the probate code and laws notify the proper people in a foreign country. But again, if it's a beneficiary designation, you might be able to do that without any issues. They just would have to be prepared to provide proper identification to establish that they're the rightful beneficiary.
Okay, excellent, Rachel. Thank you.
Mm-hmm.
All right, any other questions?
Yes, this is Rudy. Hi, Carla. And
Hi,
thanks
Rudy.
a lot, Rachel.
You're so welcome. Hello.
I have a question on that estate tax. I believe you said there's a $15 million here in Wisconsin that can
Federal.
be transferred without
Federal. So it applies
Federal.
in every state because it's a federal overarching estate tax.
Okay, so say I pass and I have money invested and it's accumulated monies in there, and now the stocks have to be sold. So then does my spouse have to pay the taxes on that amount that the stocks have made?
Well, that's a great question. And so now what we're talking about are a couple different types of tax, okay? And so what I say about taxes are like wolves, they hunt in packs, okay? And so estate tax is one wolf, there might be others behind you. So high level here, what you're talking about would be capital gains taxes, okay? You're talking about, yep, but here's the deal. This applies with the federal government, and it applies with, I'll just use, my home state of Minnesota here too. The rule is if you own this asset, you own that stock when you die and it's gain, okay, for estate tax, it's a trade-off. There may be estate tax if you go over the 15 million. However, you get, or your estate gets, a step up in basis on that asset, okay? Because you owned it in your name on your date of death. So at that point, okay, the stock is now valued, its fair market value as of your date of death. That's the new basis in that stock. So if you're leaving that stock, it doesn't matter if it's to your wife or to children, wherever you're leaving that, that new basis applies going forward. So very little, okay, in capital gains tax if they turn around and sell it, okay, after your date of death because of that step up.
Oh, so really there is no penalty on, you're not paying anything more. You're going to get it at that basis.
You get a step up in basis, right? If you inherit it, you get a step up in basis on the decedent's date of death. It's the fair market value on their date of death. Now, let me be clear here. That's a very different situation than if you were to say, maybe next year you're going to gift that stock, okay, to a child. That was a lifetime gift that you made. You don't own that stock, okay, during or at your date of death. You had given it away. Gifts you make during life, that is carryover basis, okay? So you're giving that stock in this example to a child, but you're also giving that child your cash basis in that asset, okay? So they don't get a step up. If they inherit it from you, there's a step up. If they get it during life, then no step up.
How does that work for accounts that are IRAs or 401ks?
Yeah,
Is this the same thing?
Well, here's the unfortunate thing about these assets. So basically, your IRA is now subject to the Secure Act, okay? And so now when you pass, whatever is left in that account, okay, this was a pre-tax account, and it doesn't matter if you pull funds out or your beneficiary pulls funds out, okay? Whenever someone pulls funds out of this, not a charity, but non-charitable beneficiaries, if they pull funds out, tax applies. So these days, because of the Secure Act, your beneficiaries, a non-spouse beneficiary, most beneficiaries have a 10-year window in which they are required to pull all of the funds out of your account, okay? 10 years after you die, pull all the funds out of your account. And they can pull all of it out at once. They can pull the same amount out every year. They can stagger things and pull it out when they feel like it, but it has to come out within that 10-year period. And the tax does apply, and it's an ordinary income tax.
So it'd be better kind of spread it out so you don't take a big beating on the full lump sum.
A lot of them do, yeah, and they'll talk with their CPA or their financial advisor to determine, maybe this year's not my year. Maybe I had a high income year, so I don't want to pull funds out. Maybe next year's a better year. And so, that 10-year window is there to allow somebody to, make some adjustments along the way. But, this Secure Act really got rid of that stretch IRA. It used to be that you could stretch out, take required minimum distributions out of an inherited IRA and stretch it out over your life. The Secure Act really obliterated that.
Okay. One last question, which I don't think there's anything to it, but is there any way that you could protect your money when you get sick? You might get sick
Oh, you
and start
mean
accumulating a lot of bills. There isn't anything that you can do. This is all estate planning after you die, It's not like before we die.
Well, part of the benefit, okay, of keeping assets in a trust for beneficiaries, okay, is that there are provisions, we call them credit shelter trusts, okay? And this would be if it was your trust and you set this up and now you've passed, and the direction is that the funds stay in a trust for the beneficiary. Trustee can make discretionary distributions during the course of the beneficiary's lifetime. And we do that, those are credit shelter provisions because we are planning for the possibility that the beneficiary may get themselves into a sticky wicket, right? And if they have a creditor and the creditor says, hey, I want your trust account, then it's designed so that the creditor can't, okay, crack that trust open and reach those assets. Now that works if it's a trust that's set up for somebody's benefit that isn't you, okay? So if you set up the trust for yourself to, protect from your creditors, then it gets a little trickier to do, okay? Because there are certain laws on the books, okay, that, allow you to transfer your resources into a trust like that. But, perhaps only if you don't already have creditors, right? So you're not defrauding a creditor actively. A fraudulent transfer isn't being done, but certain states, South Dakota is one, Minnesota's not, allow you to set up your own trust and be the beneficiary of your own trust. So, you put assets in there, not while you're being actively sued by a creditor, but, before, and then you then have use of those funds if you are sued later. And those are types of trust, they're irrevocable and they're not as easy, okay, to put together. There are more concerns that we look at before we do that, but those types of trusts might be appropriate, okay, for entertainers, athletes, people who are sued because they have a lot of money and they're trying to protect assets. Okay, those are asset protection trusts.
Can I
Yeah, so
interrupt?
that's kind of what I was asking about. And just in case something like that goes wrong, I want to be protected.
If I can interrupt for a second too, Rudy. So I think what you're looking for is protection against being sick or long-term care as well.
Yes.
Okay, so that's a specialty area, and Rachel may specialize in that. That's called where you have an attorney that knows the elder care laws, which means usually we recommend looking at that sometimes, when a person's healthy and so forth, but usually when they do get sick, there's trusts that attorneys they have to be specialized in elder care attorney law, and that they can help preserve assets against spend down of long-term care costs.
Yeah. And it really depends on your state, because certain states, you can't. Minnesota, you can't. It's a matter of public policy. You can't set up a trust for yourself and then, use that in a spend down situation. Minnesota would require the assets of the trust to be used to contribute to your care. So very state specific on that.
So that would be in the state of Wisconsin, a specialist, and we have some names in Wisconsin, Rudy, if you're interested.
Sure.
But that would be state specific. Yep.
All right. Thanks a lot.
Yep. You're welcome. All right. What I would recommend, thank you all for being on the call. Reach out to your financial advisor if you have any other additional questions. And we thank you so much, Rachel, for giving us your time and your expertise today. And thank you all for being on the call.
Yeah, thank you, Carla. I appreciate the opportunity, and thanks to all that attended.